You know that feeling when you send a really important email and then nothing? Just crickets? It's so frustrating, right? Well, today we're going to talk about a time when one of those unanswered emails didn't just cause some frustration, it actually ended up in court. This is the story of what happens when a simple request gets completely ignored.
Seriously, what happens? If you're in an HOA or a club, you kind of expect them to, get back to you. You pay your dues, you follow the rules, but what are your actual rights when they just ghost you? This case we're diving into gives a surprisingly clear answer. All right, so let's meet the players. On one side, we've got a member named William M. Brown, and on the other, his organization, the Terravita Country Club. All Mr. Brown wanted was to see some of the club's records, which is a pretty standard right for a member. But what should have been a simple, no-fuss request, well, it blew up into a full-on legal battle.
Now, what's really important to get is that before all the drama, the system actually worked just fine. You can see here, back in early 2016, Mr. Brown's account sends a request, and boom, a few days later, Terravita provides the documents. It happened more than once. The process was there, and it was working like a charm.
But then, one day, that perfectly smooth process just completely broke down. A simple, routine request goes into a black hole, a legal deadline gets blown past, and that's exactly where this whole fight really gets started. So here's the spark that lit the fuse. On July 30th, Mr. Brown does what he's done before. He sends an email asking for records. This time, he sends it straight to the club's secretary, a woman named Fran Wiley. Seemed like a normal, direct communication.
And this number, 10, is super important. Under Arizona law, the club had exactly 10 business days to get back to him. And get back to him doesn't just mean a quick, we got it reply. It means they had to actually make the records available. 10 days, that's the law.
So, that 10-day clock ticked all the way down and then kept ticking. Nothing, not a word from Terravita. So on August 18th, after being totally ignored, Mr. Brown did the next logical thing. He filed a formal petition. And just like that, they were all headed to a hearing.
And this is where it really gets interesting. When they get to the hearing, the judge is looking at two completely different versions of the story. It turned into one of those classic he said, they said situations.
Okay, so on one side, you've got Mr. Brown. His story is simple. I sent the email and here's the proof right here. But then you've got Terravita's side, and their story kept changing. First, the secretary said, we never got it. Then she said he sent it to an address she doesn't use for club business. And get this, the club even tried to claim his email evidence was a fake.
With two stories that were polar opposites, the judge had a really basic question to answer. This wasn't about some complicated legal argument anymore. It was about, who do you believe? Did a member just make up an email? Or did a big organization mess up and then try to cover their tracks?
And the judge basically said, look, this all comes down to one thing and one thing only. Credibility. In a he said, she said fight, the whole case hinges on who seems more believable, who's telling the more credible story.
And the judge's decision was delivered in two swift, powerful statements. First, when it came to Mr. Brown, she was blunt. His testimony was credible. She believed him.
And then, just as quickly, she gave her finding on the club's secretary. Her testimony? Unreliable. That one word, unreliable, just completely demolished Terravita's entire defense. So once the judge decided who was telling the truth, the rest was easy. Mr. Brown had proven his case by what's called a preponderance of the evidence. That's just a fancy way of saying his story was more likely true than not. The final verdict? Terravita had broken the law. So, okay, we know who won, but what's the bigger lesson here? Let's take a look at the actual law that was at the center of this whole thing and what the real-world consequences were for the country club. So this is the rule that mattered. It's an Arizona statute, and it's incredibly clear. It says an association must make its records available to any member who asks. And it gives them that firm deadline, 10 business days. This isn't a friendly suggestion. It's a legal requirement designed to make sure these organizations are transparent with their members.
So because they lost, Terravita didn't just get a slap on the wrist. The judge laid down three very clear orders. First, Mr. Brown was officially declared the winner. Second, the club was ordered to finally hand over the records within, you guessed it, 10 days. And third, they had to cut a check to Mr. Brown to pay him back for his $500 filing fee.
And check this out. This is the actual document, the official, legally binding final order. This piece of paper is what turns a judge's opinion into a command that you have to follow. It's a pretty powerful reminder that these rules have real teeth.
When you step back and look at it, this whole thing, lawyers, hearings, a binding legal order, it all happened because of one email that someone didn't answer. It just goes to show you that your rights as a member are protected by law, and ignoring them can have very real consequences. So it kind of makes you think, doesn't it? How transparent is your own HOA or club? Would they answer your email?